Washington Journal continues.
Amika Dia is at our desk this morning. She's Senior Policy Counsel for Consumers Union, here to talk about a consumer's right to sue. This comes as General Mills put a policy in place, then reversed itself recently. So what happened with General Mills?
So last week, the New York Times reported that General Mills quietly changed its legal terms. And what they said on their website, with a small gray banner on their homepage, was if you joined it in an online community, if you through their Facebook page, if you downloaded a coupon, if you entered a sweepstakes, or interacted with it in those kinds of ways, you were effectively, as a consumer, giving up your right to sue them in a court of law for a claim that you might have against them. They were instead saying that you were bound to forced arbitration, which is outside of the court process to resolve disputes, which we think shouldn't be forced upon consumers, at the very least without their consent.
And then what happened after that?
So there was quite a bit of pushback on General Mills. There was a lot of discussion on social media, the very same social media that they were trying to use to get consumers to disengage with some of these rights. And then over Easter weekend, they put out a statement that said, we're going back to our old legal terms. We've gotten quite a bit of pushback. They claim that some of the press that they got, misunderstood their intent, but they said very clearly that they stipulate for all purposes that their previous legal terms were reinstated, and that the arbitration provisions don't have any legal effect. So that was the right thing to do, and we were glad to see that happen.
Here's a little bit from their statement. We've listened and we're changing our legal terms. As has been widely reported, General Mills recently posted a revised set of legal terms on our websites. Those terms and our intentions were widely misread, causing concern among consumers. So we've listened and we're changing them back to what they were before. We rarely have disputes with consumers, and arbitration would have simply streamlined how complaints are handled. Many companies do the same, and we felt it would be helpful, but consumers didn't like it. I want to focus on this part. Many companies do the same.
Yep. Yeah, what's interesting about this General Mills case is that I think it highlighted for people how many companies, how many of the contracts that they sign every day contain in very fine print the signing away of your right to sue. And we think that forced, binding, mandatory arbitration, and I can break those terms down, is not right. It doesn't treat consumers fairly, takes away rights that they have should they be wronged by a particular product or service.
When does a consumer enter into a contract with a company that they're purchasing cereal from, or whatever it may be?
You would be surprised. I think anytime you're engaging with a company and you get that little box that pops up before you enter your, you join their, community online, or if you are downloading a coupon, a lot of us have seen that box that pops up and it has tons and tons of fine print that you've got to scroll through. You got to get your magnifying glass out and look at it, and there's a little box at the bottom that you click on that says I agree. When you see that kind of fine print that comes up like that, whether it's in a contract at a store or online, you need to be on the lookout for any clauses regarding binding mandatory arbitration, and that's where those things can be hidden.
What are some of the other companies that have similar policies?
You'll see them in a lot of places. You'll see them with cell phone contracts, credit card contracts. You'll see them with nursing home contracts. You've seen them in a wide array of financial products. So they're quite ubiquitous and can be quite harmful to consumers.
The ABC News website says that coffee company Starbucks, for example, has similar language in its gift terms and conditions related to binding arbitration.
Yes.
What do they say?
Yeah. So what binding mandatory arbitration is it's mandatory. You don't have a choice. It's not voluntary. You can't choose whether or not, if a dispute arises, let's say you've got a claim for a product defect against a particular company, or you've got a contractual dispute because they mistreated your grandparent at a nursing home facility, you don't have a choice as to whether you want to sue them in a court of law. Mandatory arbitration forces you to go into this out-of-court process, where oftentimes you'll have arbitrators that belong to an association that gets repeat business from some of these large corporate customers. And what the binding part means is whatever judgment comes out of that, whatever award that arbitrator makes, if it goes against you, you're giving up your right to then appeal it in a court of law. So it's a significant giving up of rights without consumers' knowledge.
Do these hold up?
Unfortunately, they have. And in 2011, the Supreme Court said in a case called AT&T Mobility versus Concepcion that California law that allowed class action complaints by consumers was not, it didn't apply. That California state law didn't stand, and instead consumers were giving up their right to go after a company for a group of legitimate claims through the courts. They had to go through one-by-one arbitration. Problem with arbitration, unlike the courts, is a lot of these documents are secret. You don't see what that award was, or you don't see what the outcome was. So not only are consumers that individually may have smaller claims, but together can speak with a powerful voice to go, that can match the powerful voice of the company on the other side. But on the individual basis, they're powerless, and those fees are significantly higher for individual consumers in arbitration.
So is there a specific word that consumers should look for?
There's a lot of little words that you should be on the lookout for. Arbitration, any references to dispute resolution, alternative dispute resolution, binding mandatory arbitration, American Arbitration Association, that's one of the associations that provides these arbitrators. Be on the lookout for those words in that fine print. Sometimes you can ask and try to negotiate out, but oftentimes these are, sort of fixed contracts that come from headquarters, and the individual you're dealing with at a cell phone company or at a credit card desk isn't going to be able to change it. So what we've been urging consumers to do, and what we think is the solution, is actually legislation to take these kinds of forced arbitration out of consumer contracts.
Any movement on that?
Well, there was a hearing in the Senate Judiciary Committee last December on the Arbitration Fairness Act. That's the legislation we support. It's been introduced in the Senate and in the House. And so nothing since December, but we've been urging consumers to write to their legislators to ask them to support the Arbitration Fairness Act.
We're talking about a consumer's right to sue and the policies that companies have on that. Ami Gadia is the Senior Policy Counsel for Consumers Union, here to take your questions and comments about that. Let's talk about the role of social media, because this adds a whole nother wrinkle to this.
Yes.
So are there new rules on the books when it comes to social media? So you go on Facebook and you like something that a company is talking about, or a product that they have,
right,
and then is that evidence against you?
I think what this General Mills case highlighted is the way that companies treat social media, and the way that we ordinary consumers engage with social media could have far broader implications than any of us realize. You think you like a company's product on Facebook, or you tweet with them, and you think you have maybe a relationship, or you've got a different kind of relationship than just the ordinary purchasing of the product in the store. But consumers have to remember that this is another tool to market the product to you. And so, be mindful of the fine print. Be mindful of the fact that this is marketing. Consumers are interacting much more directly with the companies here, but I think consumers also need to remember, who has the power in this relationship? It's still not the consumer.
The New York Times, the ABC News story quotes General Mills' legal policy and a statement from General Mills that said, "This is broadly mischaracterized. No one is precluded from suing us merely by purchasing our products at the store or liking one of our brand Facebook pages. This is just mischaracterization." Let's go to Bill. He's been waiting in Bridgeport, West Virginia, Democratic caller. Hi, Bill.
Good morning, Greta.
Morning.
And this question for Ms. Gadia. I agree with a lot of what she says. Unfortunately, the loss of your consumer rights is happening more and more, where all your like cable companies and your telephone companies have been bought up in the conglomerates, to where you only have so little options, like one cable company or one telephone company. So in order to have communications or a media outlet, in order to watch C-SPAN, you have to sign for the binding arbitration, and it takes away your right to sue, which also with I used to be friends with the past Attorney General. They can't do anything either. They've tried, and then so I believe that the binding arbitration needs to be, like you'd said, it's in the legislature right now, which we have a non-working legislature. But one day we hope that that'll be taken away. But the binding arbitration, that needs to be something taken away. Consumers need the right to sue, not a frivolous lawsuit, but they need the right to sue over general policies.
Amiga Dia.
Yes, I think you make excellent points. I agree. We're not talking about somehow giving access to courts to encourage frivolous lawsuits. Absolutely not. What we're talking about is legitimate claims. As you said, if a consumer is hurt by a product, is wronged by a product, if there is a defective product, if the service was delivered in a way that hurt somebody, that's absolutely something that they should have the access to the courts to pursue if that's what they choose.
Could a state have a law on the books that says mandatory arbitration? It's not allowed in this state.
That's, I think, cast into doubt quite a bit with that 2011 Supreme Court case, Concepcion, as it's referred to. In that particular case, it was a California law that was overturned, and so I think that there's significant concern amongst consumer groups and consumer advocacy organizations that this is something that even those state laws couldn't protect people.
Denver, Colorado. Mike's watching us there. Independent caller. Hi, Mike.
Hi, good morning, Greta and Amy. A lot of politicians talk about tort reform, how that would lower the cost of a lot of goods and services. Isn't forced arbitration a form of tort reform?
You know, I think the distinction to be made, and thank you for the question, Mike, I think the distinction to be made is between mandatory arbitration and voluntary arbitration. You know, I think if you're choosing that as a particular avenue to pursue your dispute, that's one thing, right? If you're doing it, you're aware of it, you're aware of how it's different from going to court, nobody's arguing against that. Where we are seeing problems and have concerns are with the mandatory arbitration, where it's the fact that you're giving up the right to pursue something in the courts is buried in legalese that, you know, it's written in very tiny print, or you may not realize that it's in the paperwork that you get. But if you're giving away that right, you don't even know it, and it's forced upon you, that's where the concerns lie.
What are Laura's next? Huntington Station, New York. Independent caller.
Yes, how you doing?
Morning.
Morning. I've been listening to some of the other callers, and they're kind of echoing some of the concerns that I have. But with regards to that Concepcion AT&T case, and again, I'm not a lawyer, I'm a small businessman. I was reading some of the pieces where you were talking about there the unconscionable aspects of these adhesion contracts, where you look at these situations where you don't have a choice. And with regards to the Concepcion piece, you almost don't even have a choice with regards to the, I guess, class action arbitration, if it was even something of that nature, where they had ruled that it had to be a one-to-one arbitration, like there was some difference between class action and doing it as a group as opposed to doing it one-to-one, where I believe the dissent on that decision was Justice Breyer, where he had talked about what lawyer would take up a one-to-one arbitration where it was a small contract amount of some $33 or something of that nature, where it just wouldn't make sense. So it does seem to have some ability in this to limit our process of bringing somebody accountable, or because of either a product problem or of a service problem. This seems a very strange piece here.
Okay. Amiga Dia.
Again, I think you raise all excellent points. That's exactly right, that the Concepcion case said that even class action arbitration wasn't allowed. And so then individuals would be forced, even if their individual claim wasn't all that high in dollar amounts, they'd have to go and engage a lawyer to then come and do the arbitration for them. And That's absolutely right. What lawyer is going to take on a case in which the harm to the consumer is something like that nominal amount of $33? The whole point of class actions is, even though the harm to an individual consumer may not be huge, if this is something that's, fundamentally unfair, fundamentally outside of, contract law or other laws, but is happening to thousands, hundreds of thousands, millions of consumers, that's obviously a right a wrong, that should be addressed. And class action is sometimes the only way to do that fairly.
Why would a consumer do voluntary arbitration?
There's some of the reasons they might do it are to perhaps move things a little bit more quickly through rather than the court process, which can take some months or even longer. Arbitration could potentially move more quickly. But there are significant things that that they should be aware that they're giving up, in the sense of there's different evidentiary burdens that sometimes apply to the arbitrators. There's different considerations, sometimes not the same consideration of precedential law, but primarily that quicker aspect, quicker resolution to things is why things are pursued that way.
And then, if you do voluntary arbitration, can you sue? Even though you've decided to take this route? It
depends. It depends. If it's binding arbitration, even if it's voluntary, then you've said, all right, well, if I lose, that's it. And sometimes there are loser pays provisions in some of these contracts. So you may lose and then have to pay the other side's legal fees. But if it's not binding, if both sides, again, are coming to the arbitration with equal awareness, equal rights, then they can agree to appeal any award that the arbitrator gives in a court of law. But both sides have to agree to that.
Victor on Twitter wants to go back to General Mills, but all other companies too that might have similar policy. So you could be unknowingly signing a contract with a company not to take legal action if hurt by a product by clicking on a coupon?
That's what this General Mills case highlighted, that by downloading a coupon off of their website, you were potentially giving away that right to pursue them in a court of law, yes.
And again, General Mills reversed that policy and have gone back to their previous policies. We'll go to Rosa in Lorena, Texas, Republican caller. Hi, Rosa.
Hi. Yes, I was going to bring up about Pyrex. I went ahead, I was doing a roast in Pyrex, and it crystallized, and it broke in a lot of pieces, and it caused a fire in the house and in the oven, which bellowed out a lot of smoke. Well, when all that was done and over, because we had to paint the house, we had to put in a new oven and all. Mm-hmm. When I called Pyrex and told them about it, and they said, "Oh, you can't sue us because you send in that paper." I said, "What paper?" I didn't send nothing in. "Oh, well, you can't sue." I said, "But I'm not trying to sue y'all. All I'm trying to do is bring it to your attention that these Pyrex do break." "Well, there must have been a crack in it or something." I said, "No, I don't wash my dishes like that." So, I'm just telling you that I'm not going to sue. I'm bringing it to your attention. And I says, I apologize for even calling you because I thought this Pyrex product was so important to y'all. So I hung up, and then I turned around and started talking to other people around Waco, found out there was more Pyrex dishes breaking. And I said, they knew all about it. But they told me, they made me look like a fool on phone, and I just wanted to get away from them.
So, Rosa, any resolution?
Do what?
Was there any resolution?
I don't know.
Okay. All right. We'll leave it there.
Rosa, you raise, first of all, I'm very sorry that happened to you. I hope you're okay and that the house is okay. And you raise a couple of really important points. That you absolutely shouldn't, if something like that happens to you and it's a case where the glass bakeware was somehow defective and caused all these problems, you have a right to pursue that in a court of law. And to contact a lawyer and say, is this a legitimate claim? That's not something that we think you should be giving up. And, I don't know the paperwork that they're claiming that, they're saying that, you couldn't sue them, but we would, not agree with that, with the consumer giving up their rights in that way. And Just as an aside, Consumer Reports has in the past looked at glass bakeware of differing brands and has seen these very same problems. So we've come across this. It's a concern that we have generally in glass bakeware. And Rosa, I would encourage you to tell the U.S. Consumer Product Safety Commission that you've had this problem, because they track this kind of product safety concern. There's a database at a website called saferproducts.gov. If you go to saferproducts.gov, Rosa, you can fill out a little online questionnaire that tells this agency that regulates product safety that this has happened. So would just urge you to do that in addition to this issue with regards to arbitration.
Jack here in Washington, D.C., Democratic caller. Hi, Jack.
Hi, one moment. Taking you off speaker. So I'm fascinated by this whole outbreak with General Mills. I really like to point out that what it really is. It wasn't anti-consumer. It was anti-lawyer. So at the end of the day, what this prevented the consumer from doing is consulting with the lawyer when their kid chokes on a piece of cereal and showing up with 20 other people that say the same thing and suing the bejesus out of the manufacturer, walking away with a massive settlement. And that's what's going on nonstop, on and on and on. I'd be interested in knowing if there was a massing of legal groups behind all this, not just regulatory organizations. I also need to point out that, your guest today is a lawyer, but really at the end of the day on behalf of a lobby, and they have a very much a vested interest in making sure that the legal community can continue suing in an unfettered manner. So the person that raised the point earlier about this being an alternative to tort was really spot on, and I'm arguing that this was really anti-lawyer more than anti-consumer.
Okay. Hey, Jack, hang on the line, because from the General Mills statement that they put out, they wrote that this is the last bit of their statement is from their lawyers, and they wrote, "We'll just add that we never imagined this reaction. Similar terms are common in all sorts of consumer contracts, and arbitration clauses don't cause anyone to waive a valid legal claim. They only specify a cost-effective means of resolving such matters. At no time was anyone ever precluded from suing us by purchasing one of our products at a store or liking one of our Facebook pages. That was either a mischaracterization or just very misunderstood. Not that any of that matters now. On behalf of our company, our brands, we would like also to apologize. We're sorry we even started down this path. And we do hope you'll accept our apology. We also hope that you'll continue to download product coupons, talk to us on social media, or look for recipes on our websites." Oh, and we lost Jack in D.C. But if you want to respond to what he had to say.
So, I think those are some common misperceptions about what is involved in these kinds of lawsuits. I think the common perception, or the common misperception, I should say, is that, people are just going to lawyers' offices and turning these cases around, and they may not have any merit. They may be, as you said, the kid choking on cereal, and that they're suing and getting tons of money out of these cases. And the reality is very different, that, you've got to have, we're talking about legitimate claims, not frivolous claims. The courts have their own mechanisms for taking out frivolous claims. But if someone's got a legitimate claim, they were made very ill by a particular food product, or they were harmed, like the woman who called from Texas with regards to the glass bakeware situation, that's something that they should then, as a consumer, be able to pursue. And I understand that people feel like this is all about lawyers, but what people need to keep in mind is that consumers are very often not aware that they're giving away these rights. If you were to ask the average consumer, hey, did you know that, by the way, if this product somehow fails on you and harms you or your family members, you can't do anything about it through the court of law. You've got to go through this arbitration process. I think most people would be very surprised by that.
I want to throw another headline at you. This is in the Washington Post this morning. This is about General Motors. They filed a motion late Monday in a U.S. court to enforce a bar on lawsuits stemming from ignition defects in cars sold before its 2009 bankruptcy, as it fights proposed class action litigation that seeks to set aside the restriction. Here's a quote. New GM's recall covenant basis for the plaintiffs to sue New GM for economic damages relating to a vehicle or part sold by old GM, the company said in a filing in the bankruptcy court for the Southern District of New York. When Mary Barra was up on Capitol Hill testifying about these ignition defects, she kept referring to the new GM. Are they a new legal entity? Therefore, people are not allowed to sue them.
So we don't think so. We think that to the extent that there is a liability that GM has for the people who were killed or injured in the Cobalt and other GM vehicles that had these defective ignition switches, they should be liable. Unfortunately, it seems that they are seeking to hide behind this. From the report that you read, it seems like there may be an effort to hide behind the 2009 bankruptcy filing and restructuring. So Consumers Union, a number of other consumer and auto safety groups wrote to GM urging them to set up a compensation fund for these victims who may have been harmed by these defective vehicles. Again, to get at the concerns of the legitimacy of those claims, that will all play out. But if individuals have been harmed by errors that GM made, we don't think that bankruptcy and that restructuring should be a barrier to justice.
By the way, on the GM story here, it's the Wall Street Journal this morning that the top GM engineer is out after this recall of these cars. The GM's company's global head of engineering is leaving the company, and his duties are being split amid new fallout from the automaker's internal probe. So that in the Wall Street Journal this morning. Matt Smith on Twitter says, if a person strikes through the arbitration clause before signing it, does that render it null and void?
That's a very good question. I don't know is the honest answer. I think it depends on whether that's a form contract and there is some other language in there that says, nothing that you mark up on this contract could be in any way changing the contractual relationship. And I think rather than have to fight that in a court and see whether that strikeout actually was effective or not and protected your rights or not, we think the way to address this is to change the system and to bar binding mandatory arbitration in these types of consumer contracts.
Barry's next. Jeanette, Pennsylvania, independent caller.
Hi, thank you for C-SPAN. Two comments that actually were somewhat echoed by people who spoke earlier. One is that class action lawsuits often provide more remuneration to the counsel than to the aggrieved party. Years ago, there was a case where the people overbooked airlines, and so the aggrieved parties got coupons, and the counsel got millions of dollars in cash. And so class action lawsuits often are more valuable to the attorneys than they are to the aggrieved party. And secondly, the rest of the world has addressed this problem of frivolous lawsuits by saying that loser pays, and that would solve the whole problem. If you have a very legitimate claim, you will pursue it. If you do not have a legitimate claim, you're going to think twice because it may bankrupt you rather than bankrupt the small business you're suing. And those are my two comments. Thank you for C-SPAN.
Mary, are you a lawyer? Do you have experience with this?
No, ma'am. I'm not an attorney.
Okay. All right.
Mary, you raise a very good point regarding the coupon settlements issue, and Consumers Union has actually opposed those types of coupon settlements because you're absolutely right. What ends up happening is the individual consumer, who we're fighting for, is aggrieved and ends up getting, should that class prevail in court, the consumer could end up getting, a very small award, a coupon for some future purchase or that kind of a thing. And so we don't think that coupon settlements are the solution, as you mentioned. I think that, again, if you look at this idea of, the concerns about frivolous lawsuits, very often it depends on the individual case, it depends on the individual state, but sometimes there are provisions that do award legal fees in the case that a particular suit is brought frivolously. A case can be dismissed if it's frivolous. So those mechanisms are out there, and what we've actually seen is that with the wave with arbitration and the Concepcion case in 2011, the result is actually taking away rights of consumers.
The Federal Arbitration Act that you talked about earlier, that the Senate is looking at, there's similar legislation in the House. Does it include a loser's pay provision in there?
What it does is it says that this type of forced arbitration, the forced mandatory arbitration where the result is binding and you don't have a choice whether that's how you want to pursue your claim or not, that is not allowed. That is banned in consumer and employment contracts.
Why not include this idea of loser's pay? As Mary was talking about, people think twice before they pursue a lawsuit.
You mean in as far as any kind of court proceeding?
Right.
So as I mentioned, I think it depends really on.
Well, I was just jumping in. So losers pay included, though. Can you include it in the arbitration process as well?
Well, so it is the part of the arbitration process sometimes. What you will see, and which is, again, why consumers, unknowingly sign up for this arbitration without knowing what it really involves, is this loser pays idea. So, I think that I think what you want to do is, the important thing is to preserve the access to the courts. If someone's got a legitimate claim, there are they should be allowed to pursue that. If they don't have a legitimate claim, if it's a frivolous lawsuit, there are mechanisms to dismiss that case before it even proceeds.
Okay. And Victor on Twitter weighs in saying, if it can be proven they knew of the ignition problem prior to bankruptcy, then new GM is liable for old GM. Renee in Elgin, Illinois, Democratic caller. You're up next, Renee. Go ahead.
Yes, thanks for taking my call. I have a question that may be related to this topic. I've seen a lot of the forced arbitration or binding arbitration language inserted in employment contracts, and even to the extent when you're applying for a job online, it's one of the steps. You type in your credentials, you type in your references, and near towards the end when they're doing the EEOC type of check boxes, there'll be something, a page or more of similar language. And I'm just kind of curious how, what kind of rights, you haven't even gotten the job, and the fact that it could affect your long-term employment with a particular company. What are the options for consumers in that area?
Renee, that's a great point, and you could argue that in that particular case, you are completely without. That's a very tough situation, right? As an employee, as a prospective employee, you're applying. You don't necessarily want to make waves and raise this provision. But if you think it's not conscionable, as we don't think it is, it's very difficult to do anything about that. And so that's why the Arbitration Fairness Act, which I mentioned, which is currently it's been introduced in both the House and the Senate, it would ban those types of forced arbitration clauses in employment contracts as well. But it's to get to exactly the issue you raised, which is that you could be applying and not realizing that you are signing away rights.
Ami Gaddia is our guest here this morning. We have about 5 minutes left with her. She's Senior Policy Counsel for the Consumers Union. For more information, you can go to consumersunion.org and follow them on Twitter @ConsumersUnion. Let's hear from Louise next in Middletown, Connecticut, independent caller. Go ahead.
Yes, thank you. Thank you for taking my call. Medical malpractice is a personal issue for me. I believe my parents, although they were both elderly, their deaths were partly caused by a doctor or a hospital's bad decision. I know the Republican Congress oppose lawsuits relating to medical malpractice because doctors and hospitals have a lot of lobby power. And where my parents passed away in Florida, there's a very powerful hospital franchise, the Adventist, known as Florida Hospital. Then you cannot find a law firm that will take on a medical malpractice case. Could you please address that?
Thank you so much for your question, and I'm very sorry to hear about what happened to your parents. That's absolutely something that we've been concerned about. It's a slightly separate issue from arbitration in that there's been a lot of discussion and controversy surrounding this idea of medical malpractice and tort reform, as some other callers have referred to. And you're absolutely right that some states have passed laws that have made it very difficult to pursue even legitimate claims of medical malpractice. Again, that we think that to the extent that folks do have legitimate claims, you don't want to disincentivize them from being able to bring those legitimate claims in a court of law.
Tony in Hubbard, Ohio, independent caller. Hi, Tony.
Good morning. Thanks for taking my call. Amy, I wonder if you can address inalienable rights and the issue of how is it that contract law and clicking off this little tick in the software, our society assumes that we can give away our natural rights as human beings, and why is it that regulations seems to skirt the issue of what it is that we are really as human beings and that the government cannot take away from us? I wonder if you can address that.
You're right that we're getting these more and more complicated contracts every day, Tony, and you need to really get out your reading glasses or your magnifying glass and go through all of this fine print, and it's very difficult to sometimes really understand exactly what's being said in that contract. And so what we're dealing with here is not so much the government necessarily taking away that right, but it's the corporation saying that, listen, by clicking that you agree with this contract, you agree with this particular service that we're providing, and by downloading the coupon or buying our product, that you are giving away this right, which, like you said, we don't think that that's something that people should be doing without the information to make that choice. We believe in an informed and educated consumer who's empowered to make the choice that they want, and companies shouldn't be able to take that away in fine print.
Here's a tweet from one of our viewers. Isn't any contract you make with a company void if existing law is broken in the contract?
Oh, that's a tough one. I mean, I think what we've seen playing out both with the Supreme Court case in 2011, what we've seen at numerous, at the state level in numerous cases there, is that consumers have tried to sue, and that contract is not void, and they actually are prevented from, bringing an arbitration claim or pursuing, prevented from pursuing a class action or other lawsuit.
Pelham, Alabama, independent caller. Scarlett.
Hi, I was wondering if our guest had any statistic that she could give to get people's attention, because I think mostly we have an issue of most consumers, most Americans thinking that they're not going to be affected by certain kind of hidden removal of rights that we usually won't see in mainstream media. We're not going to see, things of how we're being taken advantage of by pharmaceuticals, or how we're taking advantage of other countries through our, economic policies. We only we see what I guess a certain group wants us to know. Does she have any information that could draw people's attention to say, you know what, this is more common than you would think? You don't want to be in this situation. And I'm very interested in this just because as a college student, I know that I have to click accept so many times now since everything's online. So I'm very interested in just trying to get people's attention.
Scarlett, you raise a very good point, that these provisions, these binding arbitration, forced arbitration provisions, really are far more widespread than people realize. They're in contracts that you encounter every day when you may not even realize that you're, in fact, signing a contract. That's what this General Mills case really brought people's attention to, that, it's not just the big purchases in life. It's not just buying a car or buying a home, but it's things like downloading a coupon to buy some cereal. It's things like, going to the store to get a new cell phone. It's things like, signing up at the store for a credit card. And so I think, short of statistics, what I can tell you is that I would urge people to go through their, a couple of days and see how many times when they click online and they're hitting I agree, downloading software or signing up for a loyalty program like the Starbucks example that Greta mentioned early on. Look through that box that comes up and just see what's buried in there, and see how many times a day, a week that you're encountering this. And I think that will really shock folks.
And by the way, General Mills did reverse its policy. The New York Times reporting on that, saying that General Mills, the multi-billion-dollar food company behind brands like Cheerios and Pillsbury, said on Thursday that an update to its new legal policies, which stated that consumers joining our online communities could not sue the company, they said that did not apply to people who visit its Facebook pages and Twitter accounts. They call it a mischaracterization, and they've reversed themselves and gone back. We'll go to Mary next in Uniontown, Pennsylvania, Democratic caller. Hi, Mary.
Oh, hi. Thank you so much. I just wanted to make the observation that I think that what can make the mandatory arbitration clause so burdensome is that it's often coupled with the requirement that the arbitration occur in a location that is set by the company. I just signed up for a service myself where I would be able to take credit cards for my small business, and it has a mandatory arbitration provision in it where arbitration will occur in San Francisco, California, which would be delightful, but not likely that I would ever arbitrate a claim that would require me to go to San Francisco, California. So that really makes it completely unusable for any small claim.
Mary, you raise an excellent point. I'm very glad that you brought that up. I'm sure that you would much rather visit San Francisco on vacation than to arbitrate a claim. You're absolutely right that what's also buried in sometimes in this fine print is that the consumer is not only agreeing to, or the small business in your case is not just agreeing to binding mandatory arbitration, but they are agreeing to arbitrate with a particular arbitration association's arbitrator in a far-flung location. It could be, you're on the East Coast, you got to arbitrate on the West Coast. You're in Pennsylvania, you got to arbitrate in San Francisco. So I think folks, again, would be surprised when they read that and realize what they're being forced to accept.
Timothy is our last here in Wilson, North Carolina. Independent caller. Hi, Timothy.
Hi, good morning. Thank you for taking my call. Yes. I think as far as consumer protection, I want to know how free trade. I notice a lot of our products, even medicine and stuff, is made in China, India. A lot of our food is made over there. We get seafood from over there, from all these other countries, and we really don't know how it's going to damage us. And then if I did have a problem, how do I go back and sue them or hold them responsible? But I think this whole notion of the free trade, which was pushed by mainly Republicans, Bill Clinton signed the bill in the bipartisanship, but with them. But they pushed this for years to get through for this globalization. Bush's father often spoke of a new world order, and he was talking about opening the markets up and making the whole world one market.
Okay, Timothy, we'll go back to your point then about when you're buying products overseas from other countries.
That's another wrinkle, Timothy. You're right in all of this. Is if you were to be harmed by a product, or if for example, your relative was treated negligently in a nursing home, and the product was made in the U.S. or the service is provided in the U.S., you can go after that U.S. company. For imported products, imported foods, if there's a U.S. agent for that particular food or product, you can go after them. But in lots of cases, there is no U.S. agent. That product is imported directly overseas, and things do get significantly trickier there for consumers. There was a problem with drywall a number of years ago that was making people, it contained a chemical that was making people very sick and causing mold problems. And a lot of that drywall was imported from overseas, and it proved very difficult to then pursue those claims. And so you're absolutely right that this is another wrinkle to things, another layer to the burdens that consumers face.
Ami Gaddia, Senior Policy Counsel with Consumers Union. Thank you very much. Appreciate your time this morning.
Great, thank you.
Coming up next, our weekly Spotlighting on Magazine series continues with Bloomberg Business Week piece, Casinos Know When to Fold 'Em. We'll talk with Brian Miller of Bloomberg Industries. He's their gaming analyst, right after this news update from C-SPAN Radio.
It's 9:17 a.m. Eastern Time. Well, the Justice Department will begin considering clemency applications from nonviolent federal inmates who've already served 10 years or more in prison. An announcement from the department is expected today. It's part of a broader Obama administration effort to trim the prison population and ease sentencing disparities involving drug crimes. An update on the missing Malaysian airliner. Officials say material washed ashore in Australia that's being examined to determine if it comes from the missing jet. Officials are not describing it at this time. Meanwhile, Australia's Prime Minister says failure to find anything in the current search doesn't mean they'll stop looking. More powerful sonar is being brought in. And a study by the UN Education Agency says cell phones could be one key to reducing high illiteracy in countries where books are rare. Paris-based UNESCO says 774 million people worldwide cannot read, and most people in sub-Saharan Africa don't own any books, but cell phones are increasingly widespread. The report says large numbers of people in such countries are now reading books and stories on, quote, rudimentary small-screen devices. Those are some of the latest headlines.